Transfer on death accounts sound great. You fill out a form, skip probate, and you're done, right? Well, maybe not. Transfer on death and payable on death accounts can seem simple up front, but they can create big problems if your beneficiary is underage, disabled, or just not that great with money. And if you become incapacitated, managing those accounts gets complicated fast. In this video, we'll talk through the two major issues with transfer on death accounts and when a revocable trust is the smarter, safer alternative. Now, do you want more practical tips like this? Click below to join our newsletter, designed for California families planning ahead. Now, banks and brokerages often offer transfer on death or payable on death accounts. We call these TOD or POD accounts. There's really no difference between the two of them. The idea is that you keep the account in your own name and the bank gives you a beneficiary designation form, and you write down on the form who you want to inherit the money in the account when you're gone. Easy, but not so fast. There are two big problems with these types of accounts. The first problem is distribution. What happens if the person you've named can't manage their money? Maybe they're underage or disabled, or they'll just blow through the money. If they're underage, someone might need to go to court to get the money for the minor into a custodial account. And if they're disabled, you've just created a major problem for them. They'll probably need a first-party special needs trust. Then if they blow through the money, well, they'll likely be bugging other family members for more money pretty soon. Now, what happens if the person you've named in the designation form has died? That account could go through the probate court process, which is expensive and time-consuming. Ugh. See my video, 10 Things I Hate About Probate. Now, if you have several transfer on death accounts, you really need to keep track of all of them, who's inheriting each account, and if that's still appropriate over the years. The second problem with these accounts is management. A transfer on death account is titled in your name, but what happens if you become incapacitated? Someone will need to use a durable power of attorney to manage that account. But here's the thing. Lots of banks don't accept powers of attorney. Maybe they want you to sign their own power of attorney form, or they want the form signed within 6 months of you using it. Neither of these things are legal for a bank to do, by the way, but they do it anyways. So relying on a power of attorney to manage assets can really be iffy.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
So what's the better option? Create a revocable living trust and title your accounts in the name of that trust. A trust is managed by the trustee and it spells out where your assets go. If you become incapacitated, the trustee can get doctor's letters showing that you're incapacitated and then take over managing the accounts titled in the trust. Banks don't argue over this. You only need to review one trust, not many beneficiary designation forms for many transfer on death accounts. Every time you update the trust, that updates where every account held in the trust will go. Now, real property is similar. There's something called a transfer on death deed. This allows you to hold property in your name and record a deed leaving the property to one or a few people. But there are so many landmines with this, I hardly ever recommend transfer on death deeds. So there's some problems that are the same as with a transfer on death account. So like if you become incapacitated, someone needs to use your power of attorney to manage the money, which can be really problematic. Also, distributions can only go to individuals, not trusts. So you can't protect the recipient from creditors or preserve their public benefits. Also, if you name more than one individual, they have to take the property as tenants in common. And those are just a few of the transfer on death deed rules that are problematic. I won't even go into the other ones. There's so many ways to mess this up. So when you create a revocable trust, you should title your transfer on death accounts into the name of the trust, and you should title your real estate in the name of the trust as well. You'll probably need to create a new trust at the same bank, a trust account, as opposed to a transfer on death account. Then you can transfer the money or investments into the new account. Done! When might you want to keep a transfer on death account, even if you have a revocable living trust? Well, let's say you have one asset that you want to pass quickly to someone upon your death. You could name that person in a beneficiary designation. Again, though, you need to keep careful watch over that one asset. And you can name the trustee of your trust as a beneficiary of a transfer on death account, so the trustee immediately has money to manage for the administration of your trust. It usually takes several weeks or even a month for a successor trustee to get access over trust assets after the settlor has died. And it can be convenient to have some of that money available during that time. The transfer on death account can provide this. So while transfer on death accounts work in some situations, they often create more problems than they solve, especially over time. A revocable trust offers more flexibility, more protection, and fewer surprises for the people you care about. Subscribe to the channel for more estate planning tips, or visit our website to see how we can help you build a plan that works.
If this video is helpful for you, share it to someone else who might benefit from it.